This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
As promised, we're now joined by Todd Lutsky from the law firm of Cushing and Dolan. The segment here is Ask Todd, and we got the phone lines open so you can ask Todd your questions about your estate plans. 888-205-2263. That is the number to call. Last few weeks, we have been getting quite a few calls, so if you do want to make sure that we get to you, call early. It's the only way to do it. 888-205-2263 again is the number, and we're happy to take your calls for, again, your questions with Todd. That number again is 888-205-2263. Mr. Lutsky, how are you today?
I'm doing great. You?
Good. I got asked yesterday if someone asked me if I could name a country that does not have the letter R in it.
Country that doesn't have the letter R in it.
And I said, no way.
No. Oh, yeah. That's good.
Yeah,
no way.
Todd, I want to talk a little bit about the current state of federal estate taxes. What are the current exemption amounts? What are the current tax rates like today?
So those are going to be changing, too, so it's good that we're sort of talking about those.
You're taking all the stuff where I'm going to go, Todd.
All right, sorry. So today...
I only asked you where they are today.
Today, I'll try to be a good witness.
Okay, I appreciate that.
Today, the Massachusetts estate tax exemption is $2 million.
Okay.
The federal estate tax exemption is $13.61 million. And the federal gift tax exemption is $13.61 million. And there are no state gift tax is, except Connecticut.
Let's say that you are over those thresholds. What's the actual tax rate? Like, how much do you actually have to pay if you're over the Massachusetts or federal estate tax thresholds?
So federally, it's a flat 40%. So if you're worth...
On the overage or on everything?
So it's on the overage. So federally, you would calculate it by saying, let's say I'm worth $20 million. And I can shelter, just round it to $13 million for easy numbers, right? So that means that there is $7 million subject to tax.
Okay.
The amount over. You take the $7 million and you hit it really pretty much with a flat 40%. There's a little bit of a calculation on a chart you use, but you're pretty close. So if you took 70 times 40%, it gives you a pretty good idea of where you're at. That's a lot of tax. $2.8 million.
What does the situation look like as we head into 2025? Are there any changes expected next year?
There is. Let me begin with the gift tax exemption, because the gift tax and the federal estate tax exemption are the same, but on the gift tax side, there's actually two components. There's something called the present interest exclusion, which means today it is $18,000 per year per person that you can give, right? And in 2025, it's going to go to 19. It increases by 1,000.
Okay.
And the federal exemption, and by the way, that's the amount you can give, as I said, annually per year per person. The federal estate tax and federal gift tax exemption are currently $13,610,000. And they are jumping up to $13,910,000, I believe. $13,009,000 and change. I don't have that exact number, but that's a big jump from $13,600,000 to $13,900,000. Okay, so those will be the new federal estate and federal once-in-a-lifetime gift tax exemptions, and the state's staying at 2.
Talking with Todd Lutsky from the law firm of Cushing & Dolan. If you've got questions about your estate plan, this is the time to talk to Todd right now live on air. 888-205-2263 is the number. We still have room on the phone lines if you've got questions for Todd. That number is 888 888-205-2263. We're going to take a quick break here, but when we come back, it's going to be right to your questions with Todd. Again, we still have room on the phone lines at 888-205-2263. Get calling. When we return, it's right to your questions with Todd. That number one more time is 888-205-2263.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. You're listening to Ask Todd with Todd Lutsky on the Financial Exchange Radio Network.
All right, Todd, we've got a few callers for you here. Let's go first to Eileen in Chelsea. Eileen, you are on with Todd Lutsky.
Hi.
Hello.
Hello.
Go ahead.
Hi. Yes, so my mom is 90, and she recently went into assisted care, privately paid.
Uh-huh.
And she is in the process of selling her condo.
Uh-huh.
So at this point, we are not sure what to do with, like, if we should just put it, where to put it for my mom, because she's going to need it for her
Care.
Yeah.
Let me ask you this. Is she going to be able to stay in the assisted living, you think, for a while? I mean, it's based on her health. It's not like it's declining and she needs to go to a nursing home?
No, we are hoping that she can stay there and go through all of her money and stay as long as possible. She's in good care. You know, she has a walker, but she's healthy.
And is there other money that your mom has? Forget the house for a minute. By the way, how much could you sell the condo for?
I'm guessing maybe 400.
All right. And is there other money that your mom has other than that 400? Let's assume that becomes 400,000 for the moment. But is there other money currently that she can use to pay the assisted living?
Yes.
About how much?
Probably about 80.
All right, so not a lot there for the assisted living at the end of the day. So the 400 sounds like it will be needed. Now, my thought would be, you know, in the event over the however long it takes to spend that 80, it's going to last over a year anyway, I would think, in the assisted living. And if you want, you can wait a year, only because if her health does decline and she went to a long-term care facility, a house by itself as a house is a non-countable asset. So at least she'd be eligible for, you know, Medicaid benefits, and you'd pay a lot less money in the nursing home if her health declines and she goes there. So, you know, I wouldn't jump to sell the house because it's a possibility that you could save it. Whereas if you convert it to money and you wait a year and she needs, the same thing happens, she needs, you know, more care, then it's money, and it's a lot harder for a 91-year-old to actually try to, you know, save those dollars. It can be done, but it's a little easier in the form of a house. Doesn't mean you don't sell it. I just want to give you those options. But if you do sell it, yeah, go ahead, sell it. The money will sit in her bank account. Hopefully one of you have power of attorney that can, you know, administer the money, pay the bills, pay the assisted living for her, and likely with a $250,000 exclusion for selling her primary residence, she's probably not going to have much capital gains tax to pay on the property. So those are your two options, but yes, you could absolutely sell it or hang on to it. Folks, speaking of hanging on to things, we have a guide that we are coming up to the end of the month on in terms of getting you this information. It is Why Name Your Estate an IRA Beneficiary. It's right near the end of the month. It is one of these assets that are very complicated in dealing with your estate from an estate planning standpoint. It has both an income tax issue and an estate tax issue, and that's what makes it complicated. It's hard to plan for. But this guide, Why Name Your Estate an IRA Beneficiary, is under the new Secure Act. It explains to you in here how you can actually name the estate, provided you generally would do this if you're married and you're at 73 years of age. You name the estate the beneficiary, and you can now shelter it for estate tax purposes and at the same time immediately protect it from the nursing home with no 5-year waiting period for the surviving spouse. Seems a little complicated, folks, but it's really worth your time to take a look at how this works. So we are at the end of the month. Call and get the guide, 866-848-5699 or legalexchangeshow.com. Again, 866-848-5699 or legalexchangeshow.com.
Todd, I've got another caller for you here. Let's go to John in Sandwich. John, what is your question for Todd Lutsky?
Thanks for taking my call.
Sure.
My father passed away in February. He was 97 years old. He has no assets, no house or anything. The only thing he has is about $90,000+ in his checking account. My question is to settle that out. Maybe my brother and I are both named in the will as the ones to get to split that money. So do I have to go to probate for that? And number two is, can we just split it out all in one chunk, or do we have to do that 18,000 bit per year?
So, yeah, that's a great question. So let me ask you a few follow-up questions, and this one is really going to be the most important. Is that account with the $90,000 in it in your dad's name alone, or does it have your name listed as a joint owner or your brother's name as a joint owner?
My name is in as a joint owner.
So this has your dad's name and your name joint on the account, correct?
Correct.
Okay, so here's the long and the short of it. And folks, this is exactly why I don't love joint accounts. But there's pros and cons here for you, John. So here's the pros and cons. One, because it's a joint account, you do not have to go to probate, okay? You do not have to go to probate. It would pass to the surviving joint owner. However, it passes to the surviving joint owner not only outside of probate, you could just go in and take the money, but you've effectively, your dad effectively disinherited your brother because it's your money. Now, I'm not saying you wouldn't do the right thing and give him half, but you don't have to. And this is why I'm telling this to everybody else that's listening. If you run into this situation, that's why we don't do this, because there's no obligation by the surviving joint owner to actually give it to the child and say, I want to do what dad wanted, and he really wanted to treat people equally. Even though his will says that, by skipping the will and bypassing the will and going directly to you, you don't have to give it to him. Now, let's assume you say, well, Todd, I want to. Fine. You're allowed to give him half, $45,000. If you want to go $18,000 per year per person, you can do that. And those don't require any gift tax filings and no gift tax at all. You have the ability, though, to give away $13.6 million without hurting you. So there'll be no estate tax or no gift tax on that if you want to just give them the 45 in one fell swoop. So that's an option for you. So those are your two options on the gifting front. Now, I would check the will, because in our document, we have a convenience clause in the will. We know people do this as a matter of convenience, right? Sometimes people just throw on, like your dad threw your name on there because, you're close by, you can pay the bills, you can access the money, and it's done out of convenience. So the benefit of that is we put in our trusts, in our wills, that say there may be joint accounts when I die, and I acknowledge that, but I want them treated as that for convenience only, and ignore the avoiding probate effect of the joint account, and instead ordering those accounts to go to probate, to go through the will, and then be paid out according to the will. So now nobody's disinherited. The upside of that is that now you don't have to worry about gifting. There's no worry about getting him $45,000 because it would be through the will and there's no gift involved. Just do it. The only downside is, it's got to go to probate in order to do that. So you got to trade those off. But the good news is we do it because we don't want to accidentally disinherit children. We don't want to have a parent, accidentally create this what could be rift that probably doesn't exist between you and your brother, but could exist among family members, saying, 3 bank accounts were in my name and they're all mine now and I don't have to give them to you. And arguably without that convenience clause in the will, the answer is, that's right, you don't have to. So keep that in mind when you're drafting wills out there, folks, if you have it. But that's the answer. Could be a little tricky. Seemed like a simple question, Chuck, but had a lot of issues with it.
Well, Todd, I certainly appreciate you joining us today. Thank you so much for the time, and we'll be talking to you soon.
Thank you. Always a pleasure.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.